My name is Lindsay Tyndall, and today we'll be talking about being prepared and getting our estate planning documents in place. If you have a question during the presentation, you can type it into the Q&A box on Zoom, and one of my colleagues will be there to answer those questions for you. We are proud to offer this series in partnership with the Los Angeles Public Library. And before we get started, I do want to tell you a little bit more about our program, Triage Health. So Triage Health is a program of our organization, Triage Cancer. And Triage Health provides free education on legal and practical issues to help people navigate healthcare through resources, materials, and events. And those include quick guides, checklists, and worksheets, as well as animated videos and webinars. And while this information is especially important when you're navigating a chronic or serious medical condition, many of these issues impact everyone, like estate planning. So whether you have a serious medical condition or not, this is information that can be helpful for anyone. Now, I want to start this conversation by recognizing how difficult of a topic this can be to talk about and even to think about. And that's not just because of the legal side of it, but also that emotional side. It can be really sad to think about what may happen when we pass away or if our health declines. But the reality is that we are all going to pass away at some point. Hopefully, that is not for a very, very long time. But there are steps that we can take to make that time easier for our loved ones. So estate planning can mean different things to different people, but we like to look at it in a very broad sense. So we think of it as the process to create a plan to ensure that your wishes about the distribution of your property, your wishes about your health care, and your wishes about caring for your loved ones are carried out in your absence. Now, looking at this slide, who of these people do you think may benefit from having an estate plan? I hope that your answer is everyone. There is a general misconception that only wealthy people need an estate plan. And while it's true that people like Beyonce and Jay-Z need an estate plan, almost anyone can benefit from having even the most basic plan in place. Certainly, a family with young children would benefit from an estate plan, but an older single woman would as well. There is another group that I want to mention. So these two girls who are likely under the age of 18, they may not be able to legally create a will, but there may still be value in documenting their wishes. The documents may not be legally binding, but for all of the same reasons that estate plans are useful for older adults, that's also true for younger adults as well. If you do not have an estate plan yet, you are not alone. A number of famous multimillionaires have died without wills, like Aretha Franklin, Chadwick Boseman from Black Panther, Prince, and more. And we know this because when these people died, they had very large estates and there were legal issues after they passed because their wishes were not made clear. In fact, 68% of Americans do not have the most basic estate planning tool in place, which is a will. So if this is your first time sitting down and thinking about this, you are already one step ahead and you're taking a step in a good direction. It can be difficult to discuss these issues, but creating an estate plan can also allow you to express your deeply held values and your personal preferences. We also look at it as a very loving thing that you can do. It can be one of the best ways to protect your family and your loved ones from arguing or having to make challenging decisions in very difficult circumstances. So it can be very loving to have an estate plan in place. And finally, preparing in advance can also provide you with the peace of mind that your loved ones will know about your wishes and that you aren't having any loose ends. But this process can also be overwhelming. So you may be thinking, where do I even begin? So you may want to start by asking yourself these questions. What do you want to have happen to your things when you pass away? Are there people that you're responsible for that you want to plan for? Are there certain causes or people that you want to support? And who would you want to make decisions for you if you're no longer able to make them for yourself? So these are some questions to consider when you are beginning this process. So first, we're thinking about what we actually own. So an estate includes all of the property that you own at the time of death. The components of your estate can be very wide-ranging. When most people think of property, they think in terms of land or a home. And in legal terms, we call that real property. But things like bank accounts, stocks, bonds, securities, pensions, Social Security benefits, and life insurance policies are all also part of a person's estate. Even payments that are owed to you, like a tax refund or an inheritance, are included within your estate. It also includes digital assets like online bank accounts or electronic devices, files or photos on your devices, email accounts, social media accounts, and more. And finally, you have your personal property. So that may be things like cars or furniture or jewelry. And once you've determined what you own, you may want to figure out what it's worth. So for many pieces of property, you could get an appraisal, which is where you go to a professional who can tell you how much that piece of property would be worth in today's market. But when we're talking about value, we don't want to forget about sentimental value. So maybe you have a piece of furniture that's been in the family for a long time that may not be worth much if you were to sell it, but it has great sentimental value to you and to your family. For example, my sister got this very beat up guitar from her father that he left to her that definitely does not have much value, but to her, it is priceless. There is more than one way that you can own property. So sometimes how you own property is determined at the moment that you get the property, and other times it is based on law. So the three most common ways that you can own property are individually, jointly, or by contract. So when we talk about individual ownership, this is where the property is going to be owned outright and no one else has a legal claim to it. So for example, if we have Jim and he purchases a car and only Jim's name is on the title, he owns that car individually. So he can make decisions about that car without the input of others. The next type of ownership is joint ownership. And there are a few different ways that we can own property jointly. The first one is called tenancy in common. And with this type of joint ownership, each individual tenant in common owns a specific percentage of the property. And they're only free to withdraw or mortgage or sell their portion of that property. And when a tenant in common dies, their share of the property is passed on to their beneficiaries. So, for example, if we have Paige and Dean who own a building together as tenants in common, and each of them own 50% of the building, when Dean dies, the ownership of Dean's 50% would transfer to Dean's niece, who was named as his beneficiary in his will. So now Paige owns 50% of the building and Dean's niece owns 50% of the building as tenants in common. Another type of joint ownership is called joint tenancy with a right of survivorship. With this type of ownership, all of the owners hold equal right to the property, and they do not need the other owner's permission to access or use that property. So if, for example, we have Emma and Ellen, and they own a bank account together in joint tenancy with a right of survivorship, Each one of them could spend money from that account without the other one's permission. But if Emma were to die, Ellen would become the sole owner of that account without ever having to go through probate, which is something we'll talk more about after we've discussed wills. The other way that you can own something is by contract. So some types of property, like life insurance or retirement accounts, are where ownership is determined by the contract itself. So with these types of property, the owner has full control over the property while they're alive, but after death, the property transfers to a beneficiary of the owner's choice. So for example, if we have Caroline who has a retirement account and she names her daughter Jane as the only beneficiary, while Caroline is alive, she has the right to withdraw or add funds to that account or even change the beneficiary. But after her death, those funds in the retirement account will go directly to Jane. So now that we've answered some of our big picture questions like what we own, how we own it, and we've thought about what our wishes might be, we want to think about what types of documents we actually need. So this is a list of some of the more common documents that may be included in someone's estate plan, and we're going to go over each of them today. So a will is a legal document that provides instructions for what you would like to have happen to your property upon death. A will is also a place where parents could name a guardian for any minor children, which is something we'll talk more about in a moment. There is some property that will not be included in a will because the ownership is determined at the time that you get it. So for example, when you buy a life insurance policy, you have already named the beneficiary, so you can't name a new one in your will. You also want to remember that you may not be able to include property in your will if it is jointly owned with that right of survivorship. There are different types of wills. So in California, you can have a written will that's prepared by a lawyer, or you could use an online service. There's also something called a statutory will, which is basically like a fill-in-the-blank will that's created by the state. So you would just input the information that is relevant to you to create your will. Or you could have a holographic will, which is a fancy way of saying that it's a will that is handwritten and signed by you. Now, each state has different rules about how to create a valid will. In California, you need to be 18 or older, and you must be of sound mind, which basically means that you know and understand what you are doing. Your will must also be in writing, and it must be signed and dated by you, and it needs to be witnessed by two uninterested people. And for someone to be uninterested means that they would not benefit from your will. So for example, you aren't leaving any property to either of those people. When you are creating the will, there are some big decisions that you would need to make. First, you want to consider who your beneficiaries are. So basically, who gets what? Maybe you want to be very general and say you leave all of your belongings to your only child. Or maybe you want to be specific and say you leave your record collection to your son and your jewelry to your daughter. If you have minor children or dependents, this is also a place where you could name a guardian. We recommend naming one primary guardian and additional alternate guardians in order of preference. I do want to recognize how difficult this can be to think about and to talk about. So to help you with this process, we created a checklist with different questions and different things to consider to help you make these difficult choices. And last, you want to consider who is going to be the executor of your estate, or this person may also be called your personal representative. The executor is responsible for ensuring that the people who are named in your will actually receive their inheritances. An executor could be a friend or a family member, or you can also hire a professional like an estate attorney or a financial advisor. But you want to consider that closing an estate can be a lengthy and difficult process. So when you are choosing an executor, you want to make sure that it's someone that you trust and someone that you believe can handle that responsibility. So to give you an idea of some of the important responsibilities that an executor has, these are just a few examples. So your executor will file your will in probate court. They will find your property and distribute it, meaning they'll have to locate things like the jewelry that you left to your daughter and make sure that your daughter receives that. They'll file your tax returns. They can set up an estate account and more. So when you're considering who you would like to be the executor of your estate, you want to take into consideration the responsibilities that that person will be taking on. It's also important to remember that you can change or revoke your will at any time as long as you are of sound mind, which again means that you know and understand what you are doing. So in order to change your will, you would use a codicil. And a codicil is a legal document that amends a previously executed will, and it's used for minor changes. A minor change might be adding or removing a particular gift or updating the legal name of someone. So maybe you have someone listed in your will who recently got married and they changed their name after marriage. So you could use a codicil to update their name. Codicils must be executed in the same way that wills are. So for example, in California, a will must be signed by two uninterested witnesses. So a codicil must also be signed by two uninterested witnesses. On the other hand, if you have to make major changes, you may consider revoking your current will and making a new one. So major changes might be completely removing a beneficiary or adding a new beneficiary, like maybe you recently had a child and you'd like to add your child as a beneficiary. Generally, if you are creating a new will, you'll want to destroy all old wills to avoid any confusion or doubt about which one is the correct one. So for example, maybe you gave a loved one a copy of your will so that they would have access to it. You'll want to make sure that that person also destroys the old copy to make sure that we just have that new copy out there. Now, some of the consequences of not having a will and the process of actually getting your property distributed can happen through probate. So probate is the process where the terms in your will are carried out following your death. At the beginning of a probate administration, a petition is usually filed by the court by your executor. Notice is given to each of your heirs or descendants. And then a hearing is held and your will is admitted to probate and your executor is formally appointed. Some of the disadvantages of probate include its public nature. So through probate, the provisions of your will and the value of your assets become public record. Also, because a lawyer's fees and executor's commissions are based on its statutory fee schedule, the expenses may be greater than the cost of a comparable estate managed and distributed under a living trust, which is something we'll talk more about soon. There is something called a small estate petition proceeding, and this is available for estates that include both real and personal property with a total value under $100,000. And it allows you to avoid formal probate, but it does still require a court hearing and formal notice to certain people. If you die without a will in place, your property will be distributed based on law, something we call intestate succession. In California, if you're married, your spouse would receive all of your community property, part of your separate property, and the rest would be distributed to your closest surviving family in a particular order that's laid out by law. If you're not married, your estate would go straight to the closest family, again, in that particular order that is determined by law. A trust is another tool for estate planning. So unlike with a will, where you're expressing your wishes for what will happen to your property after you pass away, a trust is a legal entity that will own the property. So the person placing the property into the trust is known as the grantor. And the person that the grantor chooses to oversee the property in the trust is known as the trustee. And finally, the person who receives the benefit of the property is known as the beneficiary. Property that can be held in trust might include land or buildings, bank accounts, stocks, cars, jewelry, and more. To set up a trust, the grantor lists the purposes of the trust and makes the trust property available to the trustee. Once the property is put into the trust, legal ownership of that property is transferred from the grantor to the trust itself. The trustee then has a legal responsibility to handle the property within the trust the way that the grantor has specified in the written trust agreement. So what are some of the benefits to actually establishing a trust? One of the main ones is around control. So a trust allows you to include specific terms, providing more control as to when and to whom distributions are being made. So if, for example, we have Kevin and Kevin has a daughter, Kevin's daughter can only receive a portion of her trust if she's obtained a college degree by the age of 26. So this is a provision that you could put in the trust agreement to control when that money would be available to Kevin's daughter. There's another benefit is around protection. So a trust can allow someone to provide for their heirs who may not be great at money management. So if, for example, we have Bill, and Bill has a daughter who has a gambling problem, Bill could establish a trust where his daughter would only receive her living expenses each month rather than getting a large sum of money upon Bill's death. There's also privacy and probate considerations. So some people might prefer to establish a trust so that they can avoid probate, which could reduce potential court fees and taxes, but also because they may prefer to keep their financial matters private, and probate is a matter of public record. So if that property is in the trust, it would not go through probate. There are different types of trusts. So first we have a testamentary trust. And these types of trusts are established to provide for people who need help managing their assets. So a testamentary trust can be especially useful to a parent who has young children and wants to provide for future education or future health care or just general support. They can also be helpful in meeting ongoing expenses for dependent adults with special needs while also protecting their government benefits like Medicaid. Next, we have an irrevocable trust. So an irrevocable trust cannot be changed or revoked by the grantor once it's been put into place. So these types of trusts may provide some tax benefits and also some protection from legal action or protection from creditors, but you should not create this type of trust lightly, since you would no longer have control over the property once it's been put into the trust, even if you name yourself as trustee. Next, we have a special needs trust, which is sometimes called a supplemental needs trust. And these are trusts that allow someone who has a disability to hold an unlimited amount of assets in a trust for their benefit. So the advantage of these trusts is that the assets are not considered countable assets for the purposes of qualifying for things like supplemental security income or Medicaid or other governmental benefits. A special needs trust can provide extra care over what the government provides. So for example, the trust may pay for hours of home health care in addition to those that are paid for by Medicaid. There are very specific requirements that must be met in order to establish a valid special needs trust. And then the last one we're going to talk about today is the living trust, or the inter vivos trust. And this type of trust is created while the individual is still alive, and it is generally revocable until they die. The most common way to create these trusts is that the property owner or the grantor appoints themselves as trustee, and as long as they remain alive and mentally competent, they can change or dissolve the trust at any time for any reason. Typically, a living trust becomes irrevocable when the grantor dies. Another type of document that you may consider in your estate planning is a power of attorney for financial affairs. So if you become incapacitated, you may need someone who can handle non-medical decisions for you. So a power of attorney for financial affairs is a legal document where you can name a trusted adult as your agent who would be authorized to make financial decisions on your behalf. There are two types of power of attorney for financial affairs. They are durable and springing. So a durable power of attorney for financial affairs goes into effect as soon as the document is signed. But a springing power of attorney for financial affairs goes into effect if and only if you become incapacitated. If there's no specific end date expressed, the power of attorney for financial affairs will end upon your death or if you revoke that power. So some of the duties that you could grant your agent include depositing or withdrawing funds from a bank or handling your personal matters like receiving mail or making travel arrangements. A power of attorney for financial affairs can be very useful in situations where a serious medical condition or side effects from a treatment may lead to incapacitation. So by having a power of attorney for financial affairs in place, you wouldn't need the court to appoint a guardian to make those financial decisions for you if you were to become incapacitated. You would have already made that decision and someone would already be in place to handle that. So to give you an idea of some of the things that a power of attorney for financial affairs might give your agent the ability to do, they may be able to pay your bills or handle your taxes, oversee your accounts, sign applications for you for government benefits, and more. So again, you want to consider who is someone that you would trust with this responsibility in your life before you name them as your agent. Now, there may come a time where our family or our loved ones may need to have access to our medical records. But since our medical records are private, it can be very difficult for our loved ones to access them, even if they need them for our care. So in order for your parent, if you're over 18, or your spouse or another loved one to access your medical record, you may need a HIPAA release form in place that would give them access. You may also want to consider how you want to express your wishes about things that could happen while you are still alive. So we're going to go through some of the different documents that you may have in place. So the first is the power of attorney for healthcare. And this is where you name an agent to make medical decisions for you if you're unable to express your wishes at that time. So this is a form that you can fill out where you name an agent to make those medical decisions for you if you become unable to. And this document takes effect when your primary physician determines that you can no longer understand or communicate your preferences for healthcare. If you are still able to make these decisions, but you'd like for someone else to make them for you, you can indicate that on the form. You can name an agent and an alternate agent in the event that the first one cannot be reached. However, it is never recommended to appoint co-agents. And this is also in terms of a power of attorney for financial affairs or future guardians for any children. And the rationale here is that if we have two people with equal decision-making power, it could lead to really big conflicts or confusion or tensions between family members if they disagree on a particular matter. And then that spoils the very reason why we are putting these advanced directives in place initially. So we really recommend just naming one agent and then alternate agents after that to avoid this conflict or these issues from arising. In terms of who can be your agent, it is incredibly broad. So typically, your agent does need to be 18 or older, and it cannot be your healthcare provider, your residential care provider, or an employee of one of those. But beyond that, it is a very broad definition. So maybe you want your spouse to be your agent, or maybe you have a parent or an adult child that you would like to be your agent. Maybe you have a good friend that you would want. Regardless, as long as they are over 18 or over and they are not employed in some way in regards to your healthcare, they can typically be your agent. Next, we have what's called a living will. And this is often confused with a power of attorney for healthcare, but unlike the power of attorney for healthcare, a living will allows you to express your wishes about medical care, but typically does not name an agent. So generally, a living will is for more narrow circumstances than a power of attorney for healthcare, and it would only apply to life-prolonging measures for someone who is unable to make their own healthcare decisions, and it would only operate when certain conditions are met. In California, there is a statutory advanced healthcare directive form, and it includes a living will and a power of attorney for healthcare, as well as 3 other parts. Now, the first 2 parts are optional, but that 5th part is required. So part 3 is regarding your primary physician. So you could include contact information for your physician. You may also include information about organ donation. And organ donation can mean many different things. So maybe it's about donating organs to be transplanted into people who need it. Or maybe it's about donating for research or educational purposes. Something we hear from people is that because they've had cancer or another diagnosis, they think that they cannot donate at all. But you may still be able to donate. It just may be for other purposes than transplanting into someone else. And lastly, that part 5 is that an advanced healthcare directive does need to be signed and dated in front of 2 qualified witnesses. The agent that you name in your power of attorney for healthcare cannot be a witness to your advanced healthcare directive. It would need to be someone else. One form you may consider is a do not resuscitate form. And this is a form that you can fill out to tell your medical personnel about your decision to forego resuscitative measures, which might mean chest compressions or CPR, or being put on a ventilator or more. Your DNR does need to be signed by you or your agent who's named in your power of attorney for healthcare. And your physician must also sign the form to state that you or your agent has given informed consent to the DNR instruction. Now, your agent would be the one responsible for this if you are unable to make or communicate healthcare decisions at that point. Another option is the physician order for life-sustaining treatment and the medical order for life-sustaining treatment. These are medical orders that are completed by a seriously ill person, and then they're signed by a physician. It does not replace an advanced healthcare directive. Instead, this form indicates your preferences around DNRs, whether you would want medical intervention to prolong your life, or you'd like selective treatments or comfort-based treatments to manage symptoms. You can indicate whether you would want medically assisted nutrition or to be placed on a feeding tube if needed. It can also include other orders or instructions for your care. Now, this form does not replace your other directives. Instead, it serves as doctor-ordered instructions, almost like a prescription, to ensure that in a case of emergency, you receive the treatment that you would prefer. So your doctor will fill out the form based on the contents of your advanced directives and a discussion that you have with the doctor about the likely course of your illness and your treatment preferences. This form does not expire, so it is something that you would want to review to make sure that it continues to accurately reflect what your wishes are. There are other things that we may want to consider. One of those being that we may want to have these conversations with our loved ones about our decisions. So before you're naming someone as your power of attorney for financial affairs or the executor of your estate, these are conversations that you want to have with these people so that they know ahead of time that they're being asked to do these things. You also want to make sure that you're keeping documents and property in places where you know that your loved ones have access to, or you've given your loved ones instructions on how to access them, which we'll talk more about in a bit. You may also think about your online accounts and how you want those handled after you pass. Our lives are getting more and more online. So these are things to consider, especially if there are things like pictures or videos that can only be accessed through online accounts that your family may want. So maybe you have a lot of pictures of your children on your Facebook page, and your family would want to have access to those. On Facebook, you can set a legacy contact who would get access to your account to either delete it entirely, or they could set up a memorial page for you. On Apple, you can designate a legacy contact so that that person has access to your Apple account. So maybe you keep important things in your Apple iCloud. This would help your loved ones gain access to these things. You may also want to consider funeral planning and what that may look like to you. It may be hard to think about, but if you make plans and arrangements in advance, it can make things just a little bit easier for your loved ones. So that may be deciding if you want to be cremated. It may be saying you don't want a formal funeral and you just want to have a celebration of life. You may also want to consider if there are messages that you want to share. So maybe you want to write birthday cards for years in advance, or you want to make videos for your loved ones to have. I had a friend whose father passed away after she got engaged, and he made a video for her to watch on her wedding day so that she could feel his presence there with her, even though he could not physically be there. So these are things that can be very important to our loved ones and are things that you may want to consider. Another type of insurance that you may want to think about is life insurance. So life insurance is insurance that you can buy to provide a specific amount of money to a person or people in the event of your death. So the purpose of a life insurance policy is that you can pay during your lifetime to ensure that your loved ones are taken care of financially after you're gone. So a life insurance beneficiary is a person who will receive the proceeds from the life insurance policy. So for example, if we have a life insurance policy that's worth $50,000, and you had one beneficiary, that beneficiary would receive $50,000. If you have multiple beneficiaries, so maybe you have two children and you decide to give it in equal shares to each child, then in this situation, they would each receive $25,000. When you purchase a life insurance policy, you do need to name at least one person as your beneficiary that you would like to receive the proceeds of the policy. So your beneficiary could be your children or your spouse, maybe other family members or friends. Maybe you want to give it to a charity or your estate or others. One of the first steps in buying a life insurance policy is deciding how much coverage you actually need. So one strategy is to buy enough coverage to cover at least 1 year of living expenses and to pay off your mortgage if you own your home. Some people choose to buy life insurance coverage to pay for their funeral expenses. And once you buy a life insurance policy, it is important to review that coverage once a year to make sure that it continues to meet your needs. So for example, do you have enough coverage to pay for your current expenses? Or if there were any changes in your family. So maybe you had another child or you adopted a child. You may want to make changes to your beneficiaries, which you can do at any time. When it comes to actually getting a life insurance policy, some life insurance companies go through a process called medical underwriting. And this is to determine what they'll charge for that policy. So medical underwriting could include a written questionnaire or a verbal survey, medical exams, or a review of your medical records. And typically, the healthier that a person is, the more affordable their policy will be. Life insurance companies are allowed to refuse to sell policies to people with pre-existing medical conditions. So each company can decide if or when they would be willing to insure someone who's been diagnosed with a serious medical condition. There are a few different places where you can get life insurance. So individual life insurance is insurance that is bought directly from a private insurance company. The other option is through your employer. So employer-sponsored life insurance is when your employer offers you access to a life insurance policy as an employee benefit. So these policies may not require you to provide your medical history or answer any medical questions. Your employer may also pay the monthly premiums for you, or you may have to pay some or all of the monthly premium to have that life insurance policy. There are other groups where you may be able to get access to a life insurance policy. So some professional associations, churches, alumni associations, banks, credit unions, and others may offer life insurance policies as a benefit of membership, but typically you are responsible for paying for those monthly premiums. So if you have a pre-existing condition and you find it difficult to find a policy, one option might be working for an employer that offers a group life insurance policy. Every company has its own rules, so you may consider shopping around for the right coverage for the right prices. If you've tried shopping around and you can't find a policy, one option may be a guaranteed issue policy. So again, the specifics are going to vary plan to plan, but typically guaranteed issue policies are for people between the ages of 50 and 85. And as the name suggests, you are guaranteed issue, meaning that you cannot be denied. Typically, these plans are costly and they only provide a limited amount of coverage. But the premiums are also guaranteed not to increase during the lifetime of the policy. So it may be a good option to cover things like medical bills, credit card debts, or funeral costs. And lastly, you want to think about where you are actually keeping these documents and your property and the other things that your loved ones may need access to. So, for example, right before my grandfather passed away, he was in the hospital for some time, and he made sure to tell my grandmother not to throw away his socks. Now, because he had been in the hospital for some time and he was not well, we all thought his mind was going a little bit. But when it came time to actually go through his things, we found that he had hidden cash in his socks. So if we hadn't known that, we may have just donated them or thrown them in the trash and would have had no idea. So all this to say, you want to make sure that your loved ones actually know where to find your things. So that includes your physical property, as well as your estate planning documents and other things. So maybe you want to keep things in a safe deposit box. Make sure that someone you trust has a key, or they know where they can get a key. Maybe you have a storage unit. You'll want to make sure that your loved ones know that it exists and how to access it. But it also is revolving around your estate planning documents. So maybe you want to make photocopies of them and give them to the people who may need them. Or maybe you want to save them onto the cloud. So maybe you scan the physical document and upload it to your iCloud or Dropbox or Google Drive and make sure that your loved ones know that it's there so they know where to find it when they need it. So to summarize, there are a number of different estate planning tools, and what works best depends on you and your circumstances. But regardless of what your estate plan looks like, you do want to make sure that you're reviewing it every so often to make sure it stays up to date with your family, with your assets, and with what your wishes are. You may also want to make sure that there are people in your life who know where they can find these things and this information. And you want to discuss your plans with all of those involved. So because we understand that this can be a difficult process, we have a number of estate planning tools, including our estate planning toolkit. So we have part 1, which is a document with general information that applies federally. And then we have parts 2 and 3 of our toolkit that we've designed to be state specific. So there is a toolkit just dedicated to California that has information around California's estate planning laws, as well as sample forms for some of the estate planning documents. We also have a partnership with the organization Good Trust to help you get these documents created. So you could use the promo code Triage30 and you could get 30% off at Good Trust. So in addition to those resources, we also have a number of other resources available on our website that may be helpful to you. So we have several different quick guides around these topics. We have checklists, and then we also have animated videos that can help break all of this information down into short videos that can make it a little bit easier to understand. Now, that concludes the substantive portion of my presentation for today, but I do want to let you know about our upcoming webinars. So we have one coming up on April 30th that's also about estate planning, but we also cover a number of other topics throughout this year. So we have one in June on caregiving and one in July about our rights at work. If you'd like to register for any of these webinars, you can do so on our website at triagehealth.org/webinars. Lastly, I do want to mention our legal and financial navigation program. So while we have all of these fantastic resources in place, there are times where it's just more helpful to talk about whatever you're experiencing one-on-one with another person. So through our legal and financial navigation program, you can fill out an intake form on our website and schedule a free one-on-one call with one of our staff attorneys. On this call, you'll be able to ask questions that are specific to your situation, and the staff attorney can help explain what options may be available to you and talk to you about next steps.